Is there anything that can be done to make an attorney communicate from the other side when they refuse to communicate? Hi, my name is Rafe Palmer. I'm the principal and managing partner of STG Divorce Law in Chicago and the author of the best-selling divorce book, I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds, available on Amazon, Barnes & Noble, where all great ebooks are sold, also available on Audible. Rated one of the best divorce books of all time by Book Authority. Anyway, the question is, how do you get a lawyer to comply or respond when they're not communicating at all with your attorney? There are some tools you can use. So let's go in order. First, trying to reach that lawyer, having your attorney reach that lawyer by calling them or trying to set up a phone consult or communication is important. So pestering the lawyer a little bit to get their attention and documenting their attempts in writing to communicate with them is important. So not only calling and leaving a message, but then an email saying, I called you today and I didn't hear back from you. And then I called you on X date, Y date, Z date, and I didn't hear from you. You never called me back. The lawyer sees that and they understand they're probably getting set up for a motion. That's going to be embarrassing for them when the judge sees an email attached to a motion that shows multiple attempts to contact them and they have failed to respond. So that's one effort. One effort you can make is to just make repeated contacts and document those. The next thing you can do is what your lawyer sounds like they're doing, which is a motion to compel discovery. So they send out discovery requests, be it interrogatories, requests to produce, or what have you, and then there's no response. They then have to communicate with that other lawyer to try to get that stuff, even if they're late. Then document those communications if they fail to respond, similar to what I talked about before. And only then can they file a motion to compel discovery, where they have to show that they sent out those requests and that they were ignored and that every effort was made to contact that lawyer and they failed to respond. If the motion to compel is granted, the judge will usually give them more time, not a lot of time, but some more time to respond to those requests, and potentially will enter a sanction, meaning they may have to pay attorney's fees because they forced your lawyer to file that motion. So motion to compel is a useful tool. Another couple of things you can do to motivate the attorney to respond are schedule the deposition of the other party. That is, require them to appear for a deposition. Now, you don't have to take their full deposition, and if it's early in discovery, it's probably not to your strategic advantage to take the full deposition. In Illinois, you get 3 hours, unless you get permission of the court to go longer than 3 hours. Maybe you just take half an hour or an hour deposition to get some basic information, but mostly it's to get the other lawyer to come to the table and pay attention. It's to get the other party to find out why their lawyer isn't talking to you. So it forces people to pay attention to the case. The next thing you can do is try to get a trial date scheduled, advance the ball. If a trial date is scheduled, now people start taking the case seriously and they start paying attention to discovery requests and they start paying attention to things because they know the case has an endpoint. One of the big problems in divorce is when there's no trial date set, there's no motivation for the person on the other side potentially or their lawyer to move forward in the case. They're focusing on other things. So a trial date can do a great deal to move a case forward. I hope those tips help you move forward in your case. Thanks a lot for asking the question. Please like, share, and subscribe for more on Illinois divorce and divorce tips in general. I'm Rafe Palmer.